This young boy lost his life when he was attacked in the playroom of his own home. He was just 6 years old. The people allegedly responsible were those that were supposed to be his protectors. Stories like this never make sense. They're so impossible to comprehend, but even more shocking in this case is what this dad turned killer told authorities to try to cover his tracks and put the blame on his own son. And that dad is about to learn his fate. We're on the case presented by Law and Crime. I'm Chris Stewart. Hey guys, before we get into this story, let's talk about the app Upside that gets you cash back on daily essentials like gas and groceries. Upside's a free app. I use it a lot when I pump gas, or maybe you go into a convenience store, it can work there. Fast food joint, it works there as well. And we're talking about real cash back. So after you spend, money appears in your Upside account, then you transfer it straight to your bank and you're good to go. So here's what you do. Download Upside app, it's free. Buy whatever you plan to purchase, pay as you typically would with a debit or credit card, and you get money back. So to find out how much you can save with Upside, click the link in the description or scan this QR code on our screen and use promo code OTC to get an extra 25 cents back on every gallon on your first tank of gas. A dad in Indiana is still trying to explain himself when it comes to why he killed his own son, and it seems like he's trying to make it seem as if it's not as bad as it really is. Now, you'll see what I mean when I tell you what 29-year-old Franklin Elmore said in court when he was asked whether he killed his own son. Here's a picture of that boy, 6-year-old Justin. They lived in Elkhart, Indiana. That's in the northeast part of that state. Franklin Elkhart was married to a woman named Cheyenne Elmore. She was the stepmom of Justin, the victim in this story. Now, Justin's biological mom is now being very vocal about the red flags and the warning signs that she says were missed before her son's murder. On the night of August 3rd, the authorities were called to the Elmore home because the 6-year-old was unresponsive. When Justin's mom and stepdad were asked what happened, they acted as if they had no idea. In fact, they told police that it's possible that the boy did it to himself because he had behavioral issues and would, quote, hit himself in the head. Now, when doctors took a look at Justin's injuries, that proved to be a lie. Justin had a traumatic brain injury, a punctured lung as well. That's according to the Elkhart County Prosecutor's Office. There is no way, they say, that a 6-year-old could give himself injuries that serious. The investigation unveiled a horrific home life for this little boy. Prosecutors say that Franklin Elmore would beat Justin, and Cheyenne Elmore, she's accused of taking part in the behavior as well. The couple allegedly gave this 6-year-old, quote, whoopings. They allegedly used their hands, they used a belt, and they even forced this 6-year-old to exercise for hours as punishment. He's just 6 years old. Now, as far as the evidence that prosecutors have in this case, pictures, several of them on Franklin and Cheyenne's phones, showing Justin with bruises and other visible injuries. Cheyenne has pleaded not guilty to a charge, we'll say, of murder for her alleged role that ended Justin's life. Her case is slated to go on trial next year, but Franklin Elmore, the dad who told doctors that his son must have been the one who hit himself hard enough to cause a traumatic brain injury and a punctured lung, has just reportedly pleaded guilty to killing his own son. On the night Justin died, his dad, quote, attacked him in the playroom, leading to those horrific injuries. Now, in court, it appears that Elmore still tried to make it seem like he's not the monster that he truly is. WNDU-TV was in the courtroom for Elmore's hearing. His attorney asked, quote, did you knowingly kill another human being, victim 1? Elmore replied, quote, yes, sir. The attorney then asked him, quote, do you acknowledge you physically beat your son and he died, end quote? And Elmore replied, quote, I did not mean it. Now, there were concerns about Justin's safety before he lost his life. That is according to Justin's biological mom. Her name is Miranda McBride, and she says that she tried to report the abuse of her son to authorities in Indiana months ago. Quote, they could do nothing because they didn't find any bruises, she told WNDU-TV. Now, she says that she was alerted to the abuse of her boy by Franklin Elmore's own mom. That's Justin's grandmother. Justin's dad, Franklin Elmore, he is slated to learn his fate because he is going to be sentenced on November 25th. He was going to stand trial on November 3rd before his guilty plea. Now, as for Justin's stepmom, Cheyenne, She's slated to go on trial in February of next year. Cheyenne Elmore's trial was delayed when a judge granted a motion so her attorney could review her mental health records. Now to that, Justin's biological mom told WNDU, quote, she wants to claim mental or she's got mental problems, but she didn't have mental problems to her son, McBride said. When it came to her child, she didn't have no problems. So what makes mine any different? Joining us now to dive a little bit more into this case, how this sentencing could play out, is Melba Pearson, former prosecutor, civil rights and criminal law attorney, and the host of your Resident Legal Diva here on YouTube. Always great to have you on Law and Crime. I know these stories are not easy to talk about, but I do think they're important just because they unfortunately happen so often in so many homes across the country. This one, you just have a dad who just seems to have lied straight up to law enforcement about what happened. But of course, you see, what medical records can determine. Just what stood out to you and just how this case was built up by the authorities?
Well, first of all, what stood out to me is the fact that this poor child should still be with us today. There's no reason that this child should not be playing and living their best lives and enjoying childhood rather than being in the grave. So I just want to center the victim, because that to me is critical. But I think, just in the way that this all has played out, I mean, clearly this is someone who did not have parenting skills, who did not even understand the basics of, you have a tiny child whose body is still developing, their skull is not fully formed. So any, impact has such grave results, as we saw with this child having a traumatic brain injury, commonly known as TBI. So, just seeing this is heartbreaking. It's disturbing, but of course it also really puts the importance of all of us being vigilant, because he didn't just beat this child this way for the first time. This is something that had been ongoing. The EMTs had said that it was clear the child had bruises that have healed and all of that. So this child did endure violence for a while. So for us as neighbors, as, teachers, or, moving about the community, neighbors, when you see a child who doesn't look right, you may be saving that child's life by calling authorities rather than, I don't want to get involved. And then now, the guilt of, maybe I could have done something to prevent a tragedy.
And it seems like, certainly from the boy's biological mom, who I know lives out of state from Indiana, but she says she alerted DCS. So, she, which is the Indiana agency, much like DCF, social services, and she claims that this was completely missed and something could have been done. I always think of the story that the medical records can tell in a case like this, because you have this dad who tried to actually blame it on his son, which speaks a lot to him, right? Like, it speaks a lot to him that, he's the victim. Oh my God, my son has behavioral issues. But then thankfully medicine's gotten to the point where you can determine, science can determine that just is not true. Like, as a prosecutor, how important is it that the autopsy be able to push against any sort of narrative inside the house? Because the boy is not here to tell his story, and he's too young, even had he survived, to truly probably tell the full extent of what's happening. But you have the words of one person who's accused of murder and one person who's actually admitted to it in open court.
Well, the autopsy is critical. I always look at that as the silent witness, because the medicine doesn't lie. Science does not lie, right? Sadly, people do. But science does not have an opinion. It is basically like, this is what the body presents. And I don't mean to be insensitive when I say the body, but when talking about it in the autopsy, frame of mind, it's the body that's speaking. And it's the body that's telling the medical examiner what happened, how this child died, if there were underlying medical conditions. Was this an accident? Was this a homicide? Was this suicide? That is all something that the medical examiner determines when they're going through their examination. And as a prosecutor, you need to understand every single angle of it to really make sure that you can adequately communicate to the jury, okay, this is why what the defense is saying, does not hold water in any way, shape, or form. Obviously, the medical examiner will testify at trial if the stepmother goes to trial. But again, you have to be very in command of those facts to be able to explain it to the jury and bring them home to a guilty verdict.
The dad, Franklin Elmore Jr., he is now a convicted murderer. He has pled guilty to this charge and admitted in open court that he did do this, and frankly, that he lied as much as he did. But it's interesting because just reading off of WNDU, which is the local TV station that's been covering this case in Elkhart, Indiana, that they go to the DA's office after he enters his plea, and it was, is there some sort of deal in place? And the DA reportedly said there's no deal. This is just him pleading guilty to this charge. Knowing that this wasn't a deal to get him to plead guilty, and he was going to start his trial this month, why would somebody just plead guilty like this, as opposed to, for as horrific as the details are and he's admitting to it, at least try their hand at a trial and see if something can happen?
Well, I mean, there's a number of reasons why. I mean, he could have had a come to Jesus or whatever higher power moment, right? Where it's like, listen, I know I did wrong. It could be a situation, maybe a family member, mother, someone like that being like, listen, you need to take responsibility for what happened. Or just, maybe being haunted, by his child's cries, because that's something he's going to have to live with for the rest of his life. So, again, maybe just that overwhelming guilt caused him to plead guilty, which, again, I'm glad he did from the standpoint of, based on the evidence, it seemed pretty clear he did it. And rather than waste court time and resources and having a jury come to have to be traumatized listening to all of this, at least he's taking responsibility. And now it's up to the judge to decide whether or not they're going to take that guilty plea into consideration, because basically what he did here was plea open to the court, basically throwing himself on the mercy of the court. So the court can still give him the maximum if they still so choose, but the court can also be like, you know what, you pled guilty, you're taking responsibility. All right, I'll take 10 years off of the maximum, and will be your sentence.
Does a defense attorney have any idea when you make the decision to have your client do that and just say, look, he's pleading guilty, here he is? Any idea of what a judge could give them? I mean, clearly in this case, he's charged with killing a young child. So it's how much can even saying you're very sorry about it in court actually help any sort of sentence or situation? But typically in these cases, when you do this type of plea, does a defense attorney have any inkling on how a judge could, based off of going that direction, sentence a client?
They may have an inkling, but they would be irresponsible to tell the client. And the reason, and I'm saying this because you can never guarantee an outcome. As a defense attorney, when you're speaking with your client, you're like, this is the universe of options. This is the minimum. This is the maximum. It could be anywhere in between. You don't want to ever be in a position like, oh yeah, you're definitely going to get 15 years if you did not actually negotiate that said deal. If it's just, well, I know this judge and I think it'll be X, that becomes very dangerous territory, because you don't want to promise one thing, the judge does something different, and now the defendant comes back and appealed saying, listen, I was told by my attorney I would get this, and now I got something else. So that would be, very dangerous. Now, again, the attorney can suggest and be like, listen, maybe if you do this, you may not get the maximum, but I can't guarantee it. That would be the best thing for them to say.
Because I imagine if you're a prosecutor and you were ready to go for trial and you felt like you had this guy dead to rights, and then you find that he does this plea, as much as maybe you're relieved that you have that conviction, that you didn't risk a guilty verdict, now it's in the hands of a judge who may or may not give the strictest, most maximum sentence that you possibly can. Do prosecutors like these type of pleas in cases like this, where you have really strong evidence, where you felt like you were ready to get that conviction, you're ready to go to trial for this, but then the person just almost surrenders at the last second and then says, let's just get to the sentencing part with the judge?
Listen, in my experience, when I was a prosecutor for close to 20 years, in my experience, the really slam dunk cases and the terrible cases do not go to trial. It's everything in the middle that's a bit more murky. So in my experience, in the cases I dealt with, if I had a slam dunk, I knew that was going to be a plea. Because you didn't want to, if the person knows, especially, in handling homicide cases, when the penalty is life, right? Or depending if you're a death penalty state, death, folks, may not want to take that risk. So, and if the evidence is strong and their attorney is telling them the evidence is strong, they're going to take a plea, because at least that'll guarantee them, all right, I may have a chance of walking free again, right? Or I definitely won't be put to death because I'm going to accept life as a plea rather than roll the dice and get the death penalty. So, those are the types of things that come into the calculus. But as a prosecutor, like I said, if the case is completely terrible, it shouldn't go to trial anyway. It falls apart and goes one way. But when it's really strong facts, dead to rights, that's usually a plea as well.
And I should mention that Indiana is a death penalty state, so that's something that may have played into the calculation by the defense attorney, even though the prosecution didn't seem to want to make a deal on that front. What will the judge consider when it comes to this sentencing? Because I think in some death penalty cases, and I'm not sure how it works in Indiana, where you have a whole sentencing portion if someone's convicted of a capital crime, but now you're going to this sentencing date where it's really just on the judge to decide whether or not this is going to be a death penalty case. How might this hearing work out in determining what this guy's fate is?
Yeah, so one thing I want to say, that the judge on his own, on their own, cannot say, I'm going to impose the death penalty. Okay. The only way you get the death penalty is after trial. So the case goes to trial, person is convicted, and then the jury comes back and says, all right, boom, we think this person's guilty. Now it's the penalty phase. And then there would be evidence presented on both sides as to whether or not they're aggravators, making this a crime that's heinous, atrocious, and cruel, putting it squarely within death penalty purview, or it's, you have the defense saying, maybe the person was intellectually disabled. Maybe the person was a victim of a crime and reacted in a certain way. Maybe the person's a survivor of domestic violence. Whatever mitigating factors they can come up with, and they will present that to the jury. And then the jury makes a determination as to whether or not the person should serve life in prison or death. Now that it's up to the judge, life is the only thing that's on the table. That's the maximum that's on the table. So the judge is going to consider the defendant's age. They're going to consider prior criminal history, if he's had prior contacts with the criminal justice system before. Were there prior child abuse complaints? I mean, we're hearing that the biological mom had been complaining for a while, so I think that's something that the judge will be taking into consideration. And of course, looking at the danger to the public, right? And of course, he was a danger to his child. Could he be dangerous to other children in the future? That's something that the judge has to consider as well. And then on the mitigating side of things, well, he did take responsibility. Was there anything else? Was there any mental health arguments to be made? So maybe PTSD or something along those lines. If there's any mitigating factors, the judge will have to consider that as well, and then make a determination.
And I think too of those sentencing hearings, and I've sat in on a few, or even I think of like a bond hearing where you have arguments that could go on for hours. It could be and however long this sentencing is, and then it seems like the judge takes, when you're in the courtroom, it feels like 30 seconds in determining whether or not a sentence is going to be, and then they read a prepared statement. This is just generally speaking, because I'm always curious about it. I mean, how many judges come in knowing exactly how they plan to rule on something like a sentence, and how much of an impact can a really compelling argument or a very powerful statement being made by the defendant actually have an impact on a judge's decision on something as serious as this?
Well, I would think that a judge would come into the courtroom with their mind maybe 75% made up, right? Because they're familiar with the facts, because they have at least, the documents that have been submitted, including the charging document, maybe some more basic information about, what happened in the case. So they have some understanding of what the facts are and maybe the criminal history of the defendant. They're also going to be aware of whatever case laws that may be surrounding any unique issues in the case. So they're already going to come in with that, like, all right, I know what I'm dealing with. Let's hear if anybody has something to say that may change my mind. I do think there's occasions where the judge comes in completely like, I don't know which way I'm going to go, but I don't feel that that's the majority of situations. Of course, you can always, with good lawyering, you can accomplish a lot of things. So
Sure.
it is possible that defense counsel can come in with a really persuasive argument saying, listen, I know the maximum is life, but I think 25 years in prison is appropriate, and let me tell you why. Or the prosecutor comes back and says, listen, nothing less than life is appropriate. Maybe you weren't aware, Your Honor, but the biological mother had reported the defendant to Children's Services, and, police had come to the house 10 times, and again, I don't know this for a fact. I'm just,
Sure.
giving examples. But, the police came to the house 10 times in the last year, so this shows that there was a pattern of abuse and that this person is just, is a danger to the community and all of that. So there is wiggle room with the argument, but I believe most judges, if they have a grasp of the facts and what's going on, their pretty much mind is made up but there is a little bit of wiggle room.
And then when it comes to DCS in this case, because there just seems to be, and maybe it's because we cover, unfortunately, the stories get to us about DCF and DCF when things are missed. I think there's a story I've been covering recently of a young girl named Jacqueline Torres in Connecticut, and she lost her life, and there were major things that seem to have been missed by DCF in Connecticut related to that case. In this case, you have the biological mom of young Justin saying that she put in a report about this, but yet you have these agencies that will say they didn't see the warning signs or they didn't see that there was abuse. And I'm sure there's many stories that are not talked about of the success of some of these programs that are stretched very thin. Just what's your read, having been a former prosecutor, when you see these types of stories and kind of just the state of child welfare agencies when it comes to these cases and just how difficult of a job that they actually have?
I'm measuring my words here because there's a lot of things I could say, but I will say this, that if we say that we're a country of, we care about kids and, kids above all else and all of that, and we're neglecting them when it comes to making sure the families have the resources they need to raise their child adequately, making sure they have the proper skills, removing a child from a home if there are severe danger signs, right? I do not think that we as a nation invest enough in that. And I always say, I don't remember who said this, but I stole this quote, but show me your budget and I will tell you your priorities. And if the budget for taking care of usually child welfare and everything having to do with kids is very low, well, clearly children aren't your priority. And so that comes back to all of us as voters, right? Again, you vote for your elected officials, and this is not, one way or the other. You vote for your elected officials, you have to understand what they're prioritizing. And if they say they're prioritizing kids and the proof's not in the pudding, they're public servants. We need to vote for people who do care. So that's just something as each of us should be thinking about every election season in terms of what are my priorities, what did they say the priorities are, and what can be done to make sure that these types of tragedies don't happen again.
Yeah, and I mean, to your point, and when you talk about voters, I mean, and we don't get political on this show, but we did have an election fairly recently, and I don't remember funding child welfare agencies, something that was in a lot of political ads that I saw, as we saw a lot of them heading into elections. So hopefully, through these stories, and you never want one to happen, that there can be some sort of effort to make sure that these cases don't continue to happen. Melba Pearson, a former prosecutor, host of Your Resident Legal Diva on YouTube. It's always great to have you on Law and Crime. These stories aren't easy to talk about, but we really appreciate your perspective on this.
Thank you for having me, Chris.
Again, Franklin Elmore will be sentenced on November 25th. That will do it for On the Case, presented by Law and Crime. Subscribe to us on YouTube and Spotify. I'm Chris Stewart. We'll see you next time.